This video has been produced for all South African citizens, but specifically for firearm license holders and license applicants. Its purpose is to give you an understanding of the objectives and principles and specific details of the new Firearms Control Act. Not all the regulations and laws of the new Firearms Control Act are presently enforced or enacted. Some requirements and regulations will come into effect in the future, but where possible, we've been as specific as we are able to. Eventually, all the regulations we discuss will be enforced. But for now, we want to give you a broad insight of what to expect in the future if you are a firearm owner or if you intend to apply for a firearm license. Let's look at why the Act was passed by Parliament. There are a number of reasons. First and foremost, the Act was developed in response to a high crime rate. Here in South Africa, we have a very high level of violent crime. Our crime statistics are amongst the highest in the world. Today you have more of a chance than ever before of being shot simply for your cell phone, your ATM card, or by disturbing a thief breaking into your house or trying to steal your car. Criminals are all too often armed and will shoot you with little or no consideration for the consequences. Even with petty crime, there is a very real danger of critical injury or death. Criminals are not afraid to gun down uniformed police officers in cold blood. In fact, they are singled out as targets. Over 170 policemen are murdered with firearms each year. So believe it, as a civilian, it doesn't matter whether you are young, old, black, white, male or female, rich or poor. The new Firearms Control Act will affect everyone. We have reached a point where we must carefully control and regulate firearm ownership. As individuals, we are increasingly at the mercy of criminals who do not hesitate to shoot and kill. The Firearms Control Act has been introduced to preserve the rights of law-abiding citizens and not to deprive responsible persons the means and the right to defend themselves, their families, or their businesses with a firearm. You will see full automatic rifles in this video, but understand they are almost entirely prohibited. The only time civilians are able to use full automatic rifles is if they are police reservists or are members of commando units. Next is the matter of illegal firearms. Many owners don't report the theft of their firearms because they are afraid of being charged with negligence, so there is no accurate number of illegally obtained firearms in South Africa. To say there are more than 500,000 illegal firearms circulating throughout the country is a conservative estimate, and this number is growing steadily. It includes lost or stolen firearms from the police, the Defence Force and security companies, firearms stolen from private owners, homemade firearms, guns smuggled over borders from neighbouring states and through our seaports. This is a serious issue that must be addressed. Okay. Then there's a concern over the lack of information of the sheer volume of legal firearms in the country. The Central Firearms Register processes about 16,000 new license and transfer applications each month, most of which are approved. About 180,000 new firearms come into circulation each year. Also, there is no broadly accessible reference material that firearm owners or license applicants can access to find out where they can go for practical training and advice, where they can practice shooting or learn about the new laws and regulations concerning firearms and ammunition. Every firearm owner should become familiar with the laws of ownership, take the time to train regularly at their local shooting range, and practice responsible, safe firearm manners and habits at all times. You have a moral and legal duty to yourself and others to train and learn all about your firearm. If you own or carry a firearm for self-defense, it's vital that you take time to learn the law, to learn how to store and use your firearm properly and efficiently. Don't assume that if you simply have a basic knowledge, you'll be able to defend yourself in an extreme situation where your life and other lives depend on your technique and skill. Discipline yourself to practice regularly. There are a wide variety of firearms available on the market, all sorts of makes and models with different features. Don't rely on the advice of friends. Go to an expert who will help you to determine which firearm will best suit your needs. The 1969 Arms and Ammunition Act is still in effect, but will be replaced in stages by the new Firearms Control Act 2000. Another reason that the new Firearms Control Act exists is that the previous Arms and Ammunition Act of 1969 had become outdated. It failed to keep pace with our social and economic changes. This document had been through some 20 legal alterations in the last 30 years. It was the right time to introduce an entirely new act. In short, the aim of the new Firearms Control Act is to reduce firearm-related violence and crime in South Africa, make firearm owners more accountable for their actions, and reduce the irresponsible use of firearms, control the possession of legal firearms, also to reduce the number of illegal firearms coming into South Africa by cutting off their sources, to change the attitude of the public towards firearms by encouraging a culture of responsible ownership, to monitor and control the whereabouts of all firearms at all times, and to give the police appropriate powers to investigate, confiscate, and arrest with a view to successful prosecution. If you are watching this video, it is evident that you are a responsible firearm owner in that you are eager to learn about the new changes to the law. If you don't already possess a firearm but are applying for a license, you've taken a step toward ensuring that you intend to become a trustworthy license holder with the necessary knowledge of the law, capable of exercising effective control and safety of your firearm at all times, and are willing to seek expert advice and training. Whether you agree with the new Firearms Control Act or not, it is your legal and ethical duty to comply with its requirements. If you do not do so, you run the risk of serious criminal charges or stiff administrative fines. In effect, if you're not part of the firearm solution, you become part of the problem. So make it your business to learn the law. Remember, to own a firearm is a huge responsibility. You have the instant capacity to kill or critically injure another human being, or possibly save a life. More than your right, it's a privilege to own a firearm. You have to earn this privilege with proof of your good intentions, knowledge, and practical skill. You have a duty to show you are fit to own a firearm. The Act consists of 21 chapters, and these chapters contain a total of 154 sections. There are 4 schedules or listed categories of offences and crimes in the Firearms Control Act. There isn't time to go through every small point, but over the next hour you'll see what it means for you as a private citizen to apply for a license and to possess a firearm. Chapter 2 deals with prohibited firearms. A prohibited firearm is one that cannot be possessed by you or licensed by the registrar. In the interest of law and order and public safety, the Minister can add to this list at any time. Remember, no person may possess a firearm unless he or she holds a license, permit or authorization issued in terms of the Act. You are not allowed to own the following: any fully automatic firearm, any cannon, recoilless gun, mortar, light mortar, or launcher manufactured to fire a rocket or grenade. Any projectile or rocket manufactured to be discharged from a cannon, recoilless gun or mortar, or rocket launcher or any imitation of these devices. So turn in that handy G6 as soon as you can to your nearest police station. You are also not allowed to own any firearm where the mechanism has been altered to discharge more than one shot with a single depression of the trigger. This means you can't own a full automatic rifle or handgun, and you can't convert your semi-automatic firearm to a full automatic. You can't change the caliber, the barrel length, the serial number, or any other identifying mark of your weapon without written permission from the Central Firearms Register. Here are a few frequently asked questions. What happens if you've got a prohibited firearm at home?
Call your nearest police station immediately. They will ask you to submit a written affidavit or statement as to the circumstances in which the firearm was discovered, or a police officer will take your statement.
Which handguns are prohibited?
Any handgun that can fire automatically or any handgun that is not licensed. It doesn't matter whether it's an inheritance or a gift. If it's not licensed in your name, it's an illegal handgun.
What threat does a homemade firearm pose for the user?
Homemade firearms cannot withstand the high pressures of commercially manufactured ammunition and can explode in your hand or your face if you shoot or discharge a bullet.
What ammunition is prohibited?
Any ammunition that can be bought in a gun shop is legal, but incendiary or explosive ammunition or projectiles are prohibited. Bullets that are designed to disintegrate on impact are illegal. Remember, you may only possess the caliber of ammunition that matched the caliber of the firearm for which you are licensed.
Because the definition of a firearm is wide, the Act has a section that excludes certain devices. The Minister of Safety and Security can add to this list at any time. The following are not considered firearms in terms of the Act. Any explosive power tool used in industrial application or used in mining and steel industry, or any abattoir humane killer bolt gun. An antique firearm, air gun, tranquilizer, paintball gun, flare gun, or deactivated firearm. Now for your most frequent questions. What is considered to be an air gun?
By definition, an air gun is a device manufactured to discharge a projectile by means of compressed gas. The caliber must be less than 5.6 millimeters or .22. An air gun caliber of more than .22 must be licensed.
How can you tell if your firearm is classified as an antique?
An antique firearm is defined as any muzzle-loading firearm manufactured before 1900 or a replica of such a firearm.
What is a deactivated firearm?
A firearm that has been changed in such a way by an accredited gunsmith so as it can never be fired again. To do this, they will weld the bolt closed or drill holes according to deactivation specifications in the barrel of the firearm.
The new Firearm Control Act's position on firearm licenses and competency certificates has been a point of some debate. This matter was carefully considered for a long time. In fact, the previous 1969 Arms and Ammunition Act even made provision for competency testing. Too many license holders don't know how to use their firearms properly. They don't take the time to learn and practice through professional trainings. This makes the police service's work incredibly difficult. Also, too many lives are lost because the wrong people are able to own and possess firearms. The first part of the test concerns your suitability to possess a firearm. The state needs to satisfy itself that you are not a danger to yourself or others around you in order for you to be issued a license for a firearm. The issue of competency certificates is probably the most important and far-reaching part of the Act concerning individual firearm owners and license applicants. A competency certificate is like a driver's license. It proves that you are fit to own a firearm in that you know how to use it safely and responsibly. A competency test is an examination that you will have to pass in order to be granted a competency certificate. There are still a few administrative and legal details to iron out, but within the next 18 to 24 months, the new law regarding competency testing will be enforced and these particulars will apply. It doesn't matter whether you've had a firearm license for many years or whether you're only recently applying for a license. You still have to have a competency certificate. The registrar will not be able to issue you with a new license and you will not be able to retain your current license unless you are able to produce a certificate. A competency certificate will only be issued to you if you are 21 years or older. However, if you are under 21, the registrar will allow you to apply for a certificate if you have compelling reasons to obtain a firearm license. A compelling reason could be that you are gainfully employed and have a critical need for protection within your specific business. In other words, if you run a high-risk service where a firearm is essential for your personal protection. Or perhaps you are a dedicated hunter, sport shooter, or a private collector. Either way, the competency test that you must pass in order to receive a competency certificate consists of two parts. This involves a screening process or background check conducted by the authorities to determine whether you are considered a fit or unfit person. You must be a South African citizen or a holder of a permanent South African residence permit. Your mental condition must be stable, and you must not be inclined toward violence. And of course, you cannot be dependent on any substance which has an intoxicating or narcotic effect, drink or drugs. In fact, you won't be issued with a competency certificate if you've been convicted of any offense in terms of this Act or the Act of 1969 and sentenced to a period of imprisonment without the option of a fine, whether the crime was committed in South Africa or outside our borders. Even if you haven't been convicted of an offense involving the unlawful use or handling of a firearm or an offense in terms of the Explosives Act, you won't be awarded a competency certificate if you've been convicted either here in South Africa or outside our country of an offense involving the following activities: violence, sexual abuse or physical abuse which occurred within a domestic relationship, fraud, or supplying false information for the purposes of obtaining a competency certificate, license, permit or authorization, sabotage, terrorism, public violence, arson, intimidation, rape, kidnapping, or child stealing. If you've been convicted of any of these offenses, you will not pass the screening process and will not be awarded a competency certificate. You will be considered unfit to possess a firearm license. The second part of the competency test involves teaching you the basic rules of the safe use and storage of your firearm. You'll undergo a practical test to satisfy the state that you are thoroughly familiar with the correct way to use your firearm. You'll also take a brief written or oral test to make sure that you are familiar with the basic laws that apply to the possession and use of your firearm. Currently, there are just over 2 million firearm owners in South Africa licensed to possess approximately 3.5 million firearms. As a result, it has been decided that this part of the test can be privatized. So certain non-government individuals and organizations that are accredited or qualified to instruct and train people in firearm use and the law will provide the necessary services and training needed for you to pass the practical part of this competency test. At the end of this program, we'll give you details of some of the organizations that you can go to for advice and practical training.
Lift the firearm, keep your head upright, remember the grip.
Now, you've probably been wondering why competency certificates have been introduced.
Now, pull the hammer back using the left thumb.
This is to make certain that people have theoretical knowledge or are familiar with the laws, including the new Firearm Control Act, and to ensure that they know about their legal requirements as firearm owners. Also to ensure that they are physically capable of exercising the necessary safe use of their firearms.
Finger on the trigger.
What are the exceptions to these requirements?
And slowly squeeze.
There are no exceptions whatsoever to this new law. Even police and military personnel will have to pass a competency test in order to retain their private firearm licenses. Any license holder of a firearm must be determined by the state as a competent or proficient person.
Pull the hammer back using the left thumb.
For what period of time is a competency certificate valid?
And slowly squeeze. Don't flinch it.
If you already own a firearm and you pass your competency test, your competency certificate is valid for a period of 5 years. If you want to apply for a firearm license, go to an accredited training instructor in order to take a competency test. When you have passed this test, you have a time limit of 5 years in which to apply to the register for a firearm license.
Slowly squeeze.
How do you apply for a competency certificate?
you have to go to accredited training institution that will train you and test your theoretical and practical knowledge. If you pass this test, the training institution will issue you with a certificate which you will be able to submit to the Central Firearms Register. The registrar may then award you a license for a firearm. Their decision will depend on whether or not you have passed your competency test and whether their screening process determines you as a fit or an unfit person to possess a firearm.
Can you apply for a certificate if you have a criminal record?
Yes, you can. However, if you've been convicted of a Schedule 1 offense involving in violence, substance abuse or firearm-related crime, the registrar probably won't issue you with a license.
Will the test be available in your language?
This will depend on the accredited institution that you go to for your training.
The new Firearm Control Act allows for different types of licenses. Whichever category you require must be determined by a good motivation or reason for your need of the particular firearm you want to own. Each type of license has a specific time period of validity. An additional license is a new concept which allows for a firearm to be licensed in more than one person's name at the same time. In other words, two or more people are able to legally possess and use one firearm. An additional license is valid for the specific time period that matches the category in which the firearm is licensed. For example, an additional license for self-defense will be valid for a period of 5 years. An additional license for occasional hunting or sport shooting will be valid for 10 years. Additional licenses will only be issued to a person who resides on the same premises as the holder of the original license. In other words, if you don't live at the same address as the owner of the firearm, you may not apply for an additional license. If either person moves from the premises, the additional license lapses or becomes invalid. An additional license applicant still has to pass a competency test to determine whether he or she is a fit or unfit person. But rest assured, a husband and wife can be licensed for the same firearm. In fact, several people can be licensed for the same firearm, provided everyone resides at the same address and is in possession of a competency certificate. If you apply for a license for self-defense, you are required to prove that there is no other way in which this need can be satisfied. You must motivate your application thoroughly, and the best thing you can do is to seek the advice of an accredited training organization or firearms expert individual to determine whether you are able to properly motivate your requirement. They'll be able to tell you if your decision to apply for a license is a practical, reasonable measure of self-defense. This way, you'll be able to provide a sound motivation for your application. A license for self-defense is valid for 5 years. A restricted firearm is sometimes very necessary. Such firearms include semi-automatic rifles or shotguns that can't fire on automatic. The firearms registrar may approve a license for a restricted firearm if you can indicate that a normal self-defense firearm just won't provide the level of protection you require. For example, if you live on a remote farm or far from the nearest police station, a restricted firearm might be justified. Only one license for a restricted firearm will be issued and is valid for only 2 years. If you occasionally hunt or do sport shooting, you may apply for an occasional hunting and sport shooting license. This license is valid for 10 years. You may possess any handgun that is not automatic, or any rifle or shotgun that is not semi or full automatic. You can license up to 4 firearms, but if you already have one license for self-defense, you may only license a further 3 firearms. Furthermore, if you have an additional license, that is, if you are licensed for a firearm that is owned by someone else, then deduct another license from your 4 licenses, leaving you with a total of 2 licenses for occasional hunting and sport shooting, 1 license for self-defense, and 1 additional license. The new Firearms Control Act allows for a maximum of 4 licenses per individual. This is the total number of firearms you will be able to own or use. Under this category, any handgun, rifle or shotgun that is not fully automatic can be licensed. In the case of a shotgun, your license is restricted to a magazine capacity of 5 rounds. To qualify as a dedicated hunter or dedicated sports person, you must be a member of an accredited organization. Your license will be valid for 10 years. You may collect any firearm that is approved by an accredited collectors organization. However, you must be a member of such an organization. This includes restricted firearms, for example, fully automatic firearms. Your license will be valid for 10 years. You can also collect any ammunition approved by an accredited collectors organization. But again, you must be a member of such an organization. You are restricted to 200 rounds of any specific caliber ammunition unless you have authorization from the Registrar of Firearms to collect more. The ammunition that you possess may not be fired. The Registrar may also provide you with permission to possess certain projectiles and ammunition discharged by restricted firearms if the propellant, explosive and cartridge has been deactivated. Your permit will be valid for 10 years.
But at least we've got it, huh?
If you apply for a license for business purposes, you can't possess any firearm except for a prohibited firearm. Special provision is made for business users of firearms, for example, security firms and the professional hunter. This license allows a person other than the license holder to use or possess the firearm. For example, a security firm employee or the client of a professional hunter. This license is valid for 2 years, but if you're in the hunting business, it's valid for 5 years. A temporary authorization is an authorization to possess a firearm for a certain time period. These authorizations are also available to non-South African citizens and temporary residents, for example, foreign diplomats or hunters from overseas. Even a tourist can apply for a temporary authorization to possess a firearm. The Firearms Registrar may grant them temporary authorization for the duration of their stay in the country. As the holder of a license, you may allow another person to use your firearm, providing they are under your direct and immediate supervision. So yes, fathers, you can still teach your sons to shoot. This regulation in the new Firearms Control Act differs from the previous one in that now your firearm must have a serial number or unique identification mark on the barrel and the receiver or frame of your firearm. The previous 1969 Act stated that a serial number only had to be engraved or stamped on the barrel. In terms of the previous Act, your firearm license was valid for as long as you lived. Now you have to renew your license. And you must apply for your renewal at least 90 days before it expires. It's important for you to know that if your renewal application has been lodged in good time, your license will remain valid until the registrar has made a decision on your renewal. People, please take note of this regulation. It's traditionally been the most ignored regulation of the previous Act. If you move, you are legally required to notify the Registrar of Firearms of your new address. If you do not do this, you run the risk of spending 2 years in prison. As well as notifying the registrar of any change of address, they need you to notify them of any change in circumstance that might happen to you, that might alter the information you've supplied on the original license application. For instance, you live on a farm and you have a license for a restricted firearm, and then you move to the city. The registrar needs you to inform them of this information. It enables them to keep track of all firearms in the country and will be of enormous assistance in the fight against crime.
When pumping it, you pump it. That's why you call it a pump action.
Validity periods for licenses or permits. All licenses and permits have a limited lifespan that varies from 2 to 10 years. So to summarize, a self-defense license, 5 years. Restricted firearms, 2 years. Occasional hunting, occasional sport shooting, dedicated hunting, dedicated sport shooting, private collection permits for ammunition or firearms, 10 years. Business purposes are divided into two categories. Hunting, 5 years, and other purposes such as a security company, 2 years. How much will a license cost you?
The fee for a license is determined from time to time, but at this stage, no new fee has been fixed. Inquire at your local police station for firearm license fees.
Will your old firearm license still be valid?
Definitely yes, your old license is still valid. However, within 18 to 24 months, the Central Firearm Register will require you to re-register your firearm according to the new Firearms Control Act.
If you already have a license, will it count in your favor when applying for a competency certificate?
No, it doesn't matter if you've had a license for 20 years. The new Firearms Control Act requires everyone to pass a competency test in order to obtain a new license or to retain their current license.
What will happen to you if your firearm was stolen and you didn't report it?
You can be charged with negligent loss of a firearm, sentenced to a heavy fine and sentenced to a period of 5 years imprisonment. Furthermore, you can be declared unfit to possess a license and may have to surrender any other firearms that you have.
What do you do if you've lost your license or have washed it in your trousers so it can't be read?
You have to apply for your license to be reissued at your nearest police station.
Chapters 7 and 8 are related to manufacturers, dealers and gunsmiths, as well as the import, export and carriage in transit of firearms and ammunition. They are not strictly relevant to you as a private or individual gun owner, and because they aren't of particular concern, we're going to move on to matters more important. Firearms and ammunition must be stored and transported in the prescribed manner. It must be stored in a safe that must be bolted to an immovable structure such as the floor or wall of your house or business. Certain industries and businesses are accredited or officially authorized to transport firearms. They are permitted to do so because they have complied with particularly strict requirements determined by the Central Firearms Registrar. As an individual, you may not carry a firearm in a public place unless your firearm is attached to your person in a holster, rucksack or similar holder. If you have a rifle or a shotgun, you must carry it in the holder designed for that purpose. It doesn't matter what firearm you have, a rifle or a handgun, you have to carry it in such a way that it is completely covered. In the future, in all probability, only government institutions and security companies will be allowed to carry firearms in a visible manner while on duty. You also have to ensure that the way you carry your firearm allows you complete control of it at all times. This means that you must carry your firearm attached to your person by a holster, moon bag, rucksack or similar holder. Ladies, if you carry a firearm in your handbag, don't put it down anywhere. Keep it over your shoulder or in your hand. What will happen to you if you don't cover or conceal your firearm while carrying it?
A visible firearm makes you a clear target for criminals. In terms of the new act, if you carry a firearm that is not concealed, you can be charged with an offense that has a heavy fine, and you could even get a 2-year prison sentence.
What do you do in summer when you want to carry your firearm?
Make sure before you buy your firearm that it suits your lifestyle, your clothing and your profile. In other words, don't go and get a 45 if you know you spend most of your time in business suits. If you're able to shoot accurately and learn how to handle your firearm well, in an efficient and judicious manner, there's no reason for you to carry a large caliber firearm.
Can you ask your wife or a family member to transport your firearm to a place where you are staying?
No, you may not. No one can transport your firearm except you or an accredited firearm courier, a gunsmith or a gun dealer.
Chapter 10 talks about ammunition and firearm parts. In the new Firearms Control Act, ammunition is much more strictly regulated. We've had no option but to change the laws regarding ammunition because of the illegal and unethical sale of ammunition and firearm parts. Firstly, you can't possess ammunition unless you hold a license for a firearm. Secondly, if you do have a license, the ammunition you possess may only be of the particular caliber specified on your license. In other words, if you have a 38, you may not possess 40 caliber ammunition. Or if you have a 40, you may not possess a 38 ammunition. However, there are exceptions to this rule. If you are an individual that has a specific permit from the registrar, for example, a permit for a private collection of ammunition, or if you are a dealer or a gunsmith, or if you have a transporter's permit. But if you have no special authorization or permit, and the police find you with ammunition that does not match your firearm specifications, or if you are found with ammunition and have no firearm license at all, you are looking at some very stiff penalties. As a private individual, you may not possess more than 200 cartridges at any one time for each licensed firearm you possess. So if you have one firearm license for occasional sport shooting or occasional hunting, and also have a firearm for self-defense, a rifle and a handgun, you may possess 400 rounds or cartridges of ammunition, provided, of course, that they are the caliber of your firearms. Provision also exists in the ammunition regulations for the minister to prohibit the purchase, possession and use of certain ammunition that is extremely dangerous if it is in the interest of public safety or needs to be banned in order to maintain law and order. An example of this is armor-piercing ammunition. If you have a firearm license and a reloading kit, you may not have more than 2,400 primers in your possession for each firearm in respect of which you hold a license. Also restricted is the possession of firearm parts, which include slides, bolts and breech blocks. You may only possess these parts if you hold a firearm license capable of bearing that firearm part, or if you hold a license relating to the trade in firearms, in other words, if you are a dealer or a gunsmith. Finally, these ammunition regulations do not apply to dedicated hunters or sports persons. By virtue of their profession, they are permitted to hold as many rounds or cartridges as they wish, and more than 2,400 primers. Now for our most frequent questions. Can an additional license holder possess 200 rounds of ammunition for the firearm that you are licensed for and possess?
Yes. An additional firearm license is allocated a maximum of 200 rounds of ammunition at any one given time.
Why are firearm parts prohibited for the private license holder?
This isn't allowed because people build up firearms from these spare parts. The police have no way of tracing these homemade firearms, and this contributes to our rate of firearm-related crime.
Can someone else reload cartridges for you?
No, definitely not. No one else can reload cartridges for you. If you reload rounds for anyone else, you are technically considered as manufacturing bullets. Only firearm and ammunition traders or manufacturers are legally permitted to manufacture or sell ammunition. And anyway, even if this matter was not a legal requirement, reloading is a precise task that should only be undertaken by someone who knows exactly what they're doing. If you make a mistake, your bullet might destroy your firearm and you could seriously injure yourself. Or you could be in a situation where it's necessary to discharge a bullet only to discover that your poor reloading technique has resulted in a dud or misfire.
You stay on a farm and have made arrangements for your firearm to be fixed or serviced in a city or town. Can your in-laws transport your firearm to a gunsmith?
No. Only you, a gunsmith or licensed firearm courier is able to transport your firearm.
Is there any annual limit on the amount of ammunition that you can buy?
There is no limit at all. You can buy as much ammunition as you like every year, providing that you possess no more than 200 rounds at any one time. Just to repeat, this maximum limit on possession does not apply to dedicated hunters or sports persons. This category can possess as much ammunition as they like.
The exemptions chapter regulates the possession of firearms and ammunition by the state and its employees. So who is exempt from these control regulations? Official institutions. They can be defined as the SANDF, the South African National Defence Force, the SPS, the South African Police Service, the Department of Correctional Services, the National Intelligence Agency, the South African Security Services, and Arms Corps, South Africa's official arms procurement agency. These institutions have their own particular laws of control and regulation that they must adhere to at all times.
Also exempt are the visiting military forces of another country. For example, the security personnel of visiting dignitaries. As an individual firearm license holder or applicant, these regulations do not apply to you. However, you still might have some questions.
Are off-duty government officials bound by the new Firearm Control Act regulations?
Even if you are a member of a government institution or a security service, the new Firearms Control Act law applies to you when you are not on duty.
Can you still ask someone to produce identification if they are in uniform?
We get the document, please.
Of course, yes. The Police Act requires all officers to produce ID documents if they are requested to do so by any member of the public.
If the registrar declares you an unfit person, this means that the state regards you as unsuitable to own a firearm. In other words, through your actions, the authorities determine that you are not able to exercise the required control and safety measures to possess a firearm in a responsible manner, and that you could be a danger to yourself and others around you. Here are the facts. The registrar can declare you unfit to possess a firearm on the grounds of information contained in a statement you have made under oath, or on the basis of information supplied by any person they have called as a witness.
Just make sure you lock him up. I don't want him back here.
Such information from yourself or other witnesses could include a domestic protection order that has been issued against you in terms of the Domestic Violence Act, that you have expressed the intention of killing or injuring yourself or any other person by means of a firearm or any other dangerous weapon.
You may be declared unfit because of your mental condition, your inclination to violence, or dependence on any substance that has an intoxicating or narcotic effect, alcohol, medical prescription, or illegal drugs. Your failure to take proper steps for the safekeeping of any firearm, including your own. Your dishonesty. For example, if you've provided the authorities with information that is false or misleading, you'll be considered unfit. However, the registrar may only declare you unfit if they have considered the matter and have satisfied themselves that you are not fit to possess a firearm. Also, a declaration of unfitness is only final if you have received a written official notice of the action against you, and if you've had sufficient time to submit to the registrar why you should not be declared unfit. However, even if you appeal against the decision of unfitness, you will remain legally unfit until the appeal is dealt with. If someone gave evidence against you in court, yet the court still finds you a fit person, the registrar needs additional evidence to declare you unfit, otherwise they'd be overriding a court decision. A court's ruling always supersedes the registrar's decision or findings. You are entitled to legal representation and can request the registrar to call any person who has made a statement to appear for purposes of cross-examination. You can also subpoena necessary witnesses to attend these meetings. The new Firearms Control Act cannot be used as a weapon, for example, by angry ex-wives or husbands or disgruntled employees. Each case will be judged on its own merits. There are two categories under which a court may declare you unfit to possess a firearm. The first category includes the South African court's conviction or a foreign court conviction of certain offences, as mentioned earlier. These crimes include offences involving the unlawful use or handling of a firearm, violence, sexual or physical abuse which occurred within a domestic relationship for which you were sentenced to a period of 5 years without the option of a fine. Also, supplying false information for the purposes of obtaining a competency certificate, license, or permit or authorization. The second category includes sabotage, terrorism, public violence, arson, intimidation, rape, kidnapping, or child stealing. If the court does declare you unfit to possess a firearm, they are required to notify the Central Firearms Register of their decision. Also, if you are declared unfit, a court order must be issued for the immediate search and seizure of all competency certificates, licenses, authorizations, permits, firearms and ammunition in your possession. From the date of your conviction or from the date of the registrar's declaration that you are unfit to possess a firearm, all your competency certificates, licenses, authorizations and permits will cease to be valid. Even if you appeal against this decision, you will remain legally unfit until your appeal is finalized.
There we go.
You must surrender all documentation for any firearms or ammunition to the nearest police station within 24 hours of a declaration of unfitness. You then have 60 days in which to sell your firearm through a dealer. If you lodge an appeal against your declaration of unfitness, this 60-day period commences once you have received final written notice from the appeal board. In this case, you can make arrangements for an additional license holder to have your firearm transferred into their name, but the application for a transfer must be made within 30 days of you being declared unfit.
Finally, your status as an unfit person to possess a firearm will last for 5 years. After this time, you can apply again for a competency certificate, license, authorization or permit. On to your frequent questions. If you have a criminal record, will you be considered an unfit person?
A criminal record doesn't necessarily mean that you will automatically be declared unfit. However, if it is a recent Schedule 1 conviction involving a crime of violence, sexual or substance abuse, or is a firearm-related crime, you will most probably be declared unfit.
You're afraid your spouse will make a false statement about you to the authorities and thereby ruining your chances of obtaining a firearm license. What should you do?
There is a legal term phrased audi alteram partem, which means you must listen to both sides of the story. There is no way to stop this sort of thing from happening to you. But remember, the police know that there are always two sides to any story. People who submit false statements will be prosecuted with the full weight of the law.
This chapter requires you to produce your license and firearm for inspection purposes by a police official or any person authorized by the registrar. First off, let me tell you that anyone who asks you to produce your firearm or your firearm license must first identify themselves to you with a necessary appointment certificate or authorization if you ask for their identification.
If you carry your firearm, you must be able to produce the license, authorization or permit in respect of the firearm you have with you at that moment of time. It's no good showing a police officer your hunting license for your rifle if you're carrying your handgun. You also have to identify yourself and produce your firearm if they ask you to do so.
If you are carrying your firearm and don't have your license with you, the officer may take your firearm without a warrant and keep it at the station until you are able to show them your license. You have 7 days to produce either your license or firearm from the day the police officer asks you to do so. If a police official has reasonable grounds to think that you have a firearm or ammunition in your possession, they can ask you questions regarding its whereabouts, as well as certain personal particulars like your age, full name, your residential and work address. They can also enter any premises, as we'll see in the next chapter. But first, let's hear some of the usual questions people ask. What do the police mean when they say they have reasonable grounds to suspect?
The basis of reasonable grounds for the police to inspect, search or enter a premises can be interpreted as either a sworn statement by an individual that is information or a clear indication of your involvement with or possession of a firearm or ammunition related to an offense. On this presumption, a search warrant is usually obtained before the search. But also, reasonable grounds can mean that the police have immediate and irrefutable information indicating your illegal possession of firearms or ammunition or your involvement with a firearms-related crime or offense. Here, a search warrant need not be issued for the police to enter a premises.
The new Firearms Control Act makes it easier for the police to successfully prosecute criminals. The new powers of search and seizure relate to the taking of fingerprints as well as bodily appearance. This law allows the police to take fingerprints, footprints or palm prints, or if you've been arrested, to take steps to see if you have any particular mark or distinguishing feature, like a tattoo or a birthmark. They can also arrange to take blood samples if they have a reasonable suspicion that you have committed any crime for which you can be convicted to a prison sentence of 5 years or more. Due to the increasing rate of violent crime in South Africa, the police have been given wide powers to search, set up roadblocks, and to cordon off areas. Now the police are able to take prints and bodily samples without a warrant for your arrest if they have reasonable grounds to suspect that you have committed an offence that is punishable with imprisonment for a period of 5 years or longer. If you are under suspicion and they have grounds to believe that an examination of your prints or bodily samples will be of value to an investigation, they may take such fingerprints or bodily samples without first obtaining a warrant. They can also search your business and residential premises, your vessel or boat, aircraft or vehicle, make the necessary inquiries, and examine any object that has a possible link to the crime being investigated. They've been given this power because sometimes it defeats the object of the search to have to obtain a warrant. Please also take note of the fact of incidental discovery. Here, while searching for anything else, if the police discover illegal firearms or ammunition, or discover that you failed to store your firearms as prescribed by the Act in a safe bolted to the wall or floor, this is admissible in a court, and you could be charged with an offence relating to the firearm or ammunition they find. If your husband or wife or child is charged with a crime and you don't live with them, can the police come and search your premises?
In this case, the police may search with or without a warrant, if it means that obtaining a warrant would defeat the purpose of a search. For example, your relative is arrested for a firearm-related crime. The police seek the court's permission for a search warrant. During the time taken to obtain a warrant, your relative could make arrangements to have someone dispose of any evidence that may implicate them in the crime. When the police arrive at your premises with a search warrant, any evidence has already been destroyed or disposed of.
Do the police have to produce a warrant for a search?
No, they don't have to.
If they don't have a warrant, do they have to provide you with a reason for their search?
Well, the police must always produce official identification and must always state the purpose of their search.
Do the police have to give you a receipt for anything they confiscate?
The police must always give you a written receipt for any and all items they confiscate or seize.
Can you insist on using your own doctor if you are required to give bodily samples?
No, you can't. You have the right to legal representation from the moment of arrest, and your representative should assist you in all legal matters regarding the taking of bodily samples. You can request that your own doctor be present during any bodily sample testing, but you cannot insist.
What happens if you are looking after someone else's property and the police insist on searching this property?
Well, you have to comply with any inspection or search of any premises or dwelling. Regardless if you are the owner or not, you will be considered to be in control of the property.
The new law of presumption of possession is a major new development. One of the problems of the old 1969 Arms and Ammunition Act was that the burden of proof was the responsibility of the accused. In other words, as an individual, if you were charged with a crime relating to firearms or ammunition, it was your responsibility to prove or provide clear evidence of your own innocence. In some instances, this was virtually impossible for a person to do. Furthermore, in terms of the old Act, even if the court was not convinced you were guilty of possession and you couldn't prove that you were not in possession, they had to convict you anyway, as this is what the South African law demanded. But this law has been declared unconstitutional and things have changed. In terms of the new 2000 Firearms Control Act, a presumption of possession requires that despite taking reasonable steps, the authorities were unable to link possession of the firearm to any other person. In order for a prosecution to be successful, presumption of the possession must also be linked to a certain set of circumstances. For example, in the case of residential premises, if an individual is in control of these premises, and this means owning or being a tenant who holds the lease, or even looking after a house for a friend while they're away, if a firearm or ammunition is discovered, then the presumption of possession will come into effect. You will be considered in possession of the firearm or ammunition. In order for you to escape prosecution, you need only to provide evidence that raises a reasonable doubt that you did not possess the firearm. This may sound like the law is making it easy for criminals to get off the hook. However, it's actually becoming much more difficult for criminals to commit crime and get away with it.
Let's say that you're driving and decide to stop and give someone a lift. As the person exits your vehicle, a firearm falls from his rucksack, but you don't notice this. According to the previous law, you would have automatically been presumed in possession of the firearm. You were in control of the car, and so you would have had to prove to the police that you were not involved and had no knowledge of the firearm. It would have been your responsibility to prove to the state that your intentions were not criminal. In terms of the previous law, you might not have been able to do that. But now things work differently. This process of elimination will help tremendously in the fight against violent crime. In the past, although the police may have been aware of just who committed the crime, they were not able to prosecute successfully. For example, someone smuggling illegal firearms on a public transport vehicle like a taxi or a bus was able to avoid prosecution by raising a reasonable doubt of their possession of an illegal firearm or ammunition through the fact that they were only one of many passengers, and so the firearm or ammunition could belong to any of these passengers. In this case, police were not able to establish a clear link to any particular individual's criminal intentions, so in most cases the criminal escaped prosecution. Now the police can secure harsh convictions for the real criminals. They can do this because now they only have to prove the firearm cannot be reasonably linked to anyone else. Now they can make use of this power to take fingerprints and other bodily samples without arresting these persons if there are reasonable grounds to suspect that one or more of these persons has committed an offense for which they can be jailed for 5 years or more. Also, that there are reasonable grounds to believe that the examination of the prints or bodily samples can include or exclude one or more of the persons as perpetrators. The new law concerning presumption of possession has been changed to assist in difficult cases, for example, drive-by shootings which involve multiple suspects. The fact that you are innocent of possession until the police prove otherwise might sound soft and easygoing, but beware. If you were in the car, the house, or anywhere in the immediate vicinity where the firearm or ammunition is found, and despite taking reasonable steps, the police are not able to link the possession of the firearm to any other person, you will be charged with an offense that is appropriate to the crime they are investigating. The moral of this story is to choose your friends with care. Don't mix with bad company, or despite your best intentions, you might find yourself on the wrong side of the law. Don't forget, if you have a criminal record, it stays with you for life. Here are the answers to a few of your questions. If you are with a group of people and they commit an offense that the police charge them with, but you didn't participate in committing the crime, will you be found guilty together with them?
This depends on whether you have associated yourself with the group's conduct or actions or not. If you have associated yourself with their conduct, you could be convicted as an accomplice.
You're in a vehicle that is stopped at a roadblock and the police find an illegal firearm or ammunition that you have no knowledge of and which doesn't belong to you. How do you prove this to the police to avoid being prosecuted?
You don't have to prove anything. You just have to provide enough evidence to raise a reasonable doubt that you did not possess the firearm or ammunition. Now, it's our responsibility to prove that the firearm is either linked to you or is not linked to you.
Although the new Firearms Control Act has put in place many laws that will be of enormous use in combating crime, it has also created an additional workload for the police service and in fact for the entire criminal justice system. So offences of an administrative or petty nature which are not hard crimes may be penalised with a fine. For example, if your licence is destroyed and you don't replace it, you'll receive a fine. The amount of these fines will be set by the registrar and they will not count as a previous conviction. So if you have to pay a fine for a firearm or ammunition offence that isn't serious, you won't get a criminal record. And like traffic fines, you'll be able to choose whether to pay the fine or go to court to dispute the offence for which you've been penalised. If you decide to pay the fine, you can't be prosecuted for the same fact in a court of law. The penalties for firearm and ammunition-related crimes and offences have changed considerably. They are a clear indication of how urgently and seriously the state considers the terrible crime problems we must overcome. Listen carefully, because these new penalties will be applied with the most rigorous enthusiasm to those people who commit offences relating to the new Firearms Control Act. You can go to jail for 2 years for the following offences. If you fail to notify the registrar of your change of address, if you are found to be carrying a firearm that is not completely covered in an appropriate holster or rucksack, or if it's found that you cannot exercise effective control of your firearm by the manner in which you are carrying it. If you handle a firearm while you're under the influence of alcohol or drugs, you could go to prison for 3 years. Under the influence of alcohol doesn't mean 2 beers or a glass of wine. It means not even 1 drink. Zero tolerance here. Firearms and alcohol don't mix. You can be punished by the court with a 5-year prison sentence for the following offences. If you are found in unlawful possession of firearm parts, or if you are found guilty of the negligent discharge of a firearm. If you discharge a firearm in a built-up area. If you fail to secure your firearm by locking it up in a prescribed safe. A court of law could send you to prison for 10 years for the following offences. If you alter the serial number or identification mark of your firearm, you get 10 years. If you point a firearm unlawfully, it doesn't matter whether it's loaded or unloaded. If you are caught carrying a firearm in a firearm-free zone, even if you are an off-duty policeman, 10 years is a long time. You can go to jail for 15 years if the police catch you with an illegal firearm or unlawful ammunition, meaning if you are caught with a firearm in your possession that isn't licensed to you, or if you are found with ammunition that is not of the specific caliber designed for your firearm. If you dispose of a firearm unlawfully, for example, if you throw it away or just give it to a friend who hasn't applied for a license. If you perform unlawful gunsmithing, in other words, if you don't possess a gunsmith license and alter or modify your firearm in any way. If you import a firearm or ammunition unlawfully. If you fail to surrender your firearm or ammunition after having been declared unfit by the authorities. Any of these offences could see you behind bars for 15 years. The following offences could put you in jail for 25 years. If you are found in possession of a military-type firearm, or if you are caught dealing in or manufacturing firearms or ammunition unlawfully. In other words, if you buy, sell or make guns or rounds without a permit, authorization or a license to deal in firearms and ammunition. If you dispose of a firearm unlawfully, in other words, if you throw it away or sell it to an unlicensed individual. Or if you are caught storing a firearm in a firearm-free zone. Commit any of these offences and you can go to prison for 25 years of your life. To answer a few questions. What will happen to you if you don't pay the required fine for a firearm or ammunition offence?
Like a traffic fine, you can be arrested.
Will a fine for a firearm or ammunition offence give you a criminal record?
Not necessarily. An administrative fine won't give you a criminal record. However, if you are convicted of a crime in the court of law, you will have a criminal record.
Chapter 17 of the Firearms Control Act deals with state organizational structures and the administrative details of the Registrar of Firearms. It is not information that is vital to you as a private firearm owner, so let's move on. If you have applied for a competency certificate, license, permit or authorization and it's been refused, or if the authorities have cancelled any of these documents, you have the right to appeal. The appeal board consists of 5 members who are broadly representative of our population. So everyone will receive a fair hearing. Please consult your nearest major police station for further details. Here are some of the questions we hear all the time. Who doesn't have the right of appeal?
Everyone has a right of appeal.
2 shots, then you're going to progress to 3 shots, and then long burst.
How do you start to exercise your right to appeal?
You or your legal representative must put your appeal in writing and send it to the appeals board in Pretoria. At the end of the video, we'll give you the address.
Will you have to pay any money for an appeal?
No, an appeal is free of charge. It would be wise to pay your lawyer, though.
If you lawfully own a firearm and ammunition and decide you no longer want it and you surrender it to your local police station, you may be entitled to compensation. However, in order to be paid compensation, you must legally or lawfully own or possess the firearm in question. If you hand in an illegal weapon or ammunition, you won't be compensated. The Minister has also made provision for amnesty periods. This means that if you are in unlawful possession of a firearm or ammunition, you can dispose of it during the announced time period without fear of prosecution.
I'm bringing it back.
So how do you find out about amnesty periods without fear of prosecution?
If the Minister of Safety and Security declares a general amnesty, it will be broadcast and published widely throughout all media channels, radio, TV and newspapers.
If you inform the police about someone else's illegal firearm during an amnesty period, will they still be prosecuted?
Oh yes, if you inform the police of someone else's illegal firearm during an amnesty period, they will investigate the case as usual. If your information leads to the discovery of a crime or a firearm, that person will be arrested and prosecuted, whether or not there is an amnesty period. However, if you hand over your own illegal firearm during an amnesty period, you will not be prosecuted for surrendering it to the police.
Can you find out how much compensation you'll receive for a firearm without handing it in?
If it's an illegal firearm, you will not receive compensation. If you have a legal firearm you want compensation for, inquire at your nearest major police station.
The new Firearms Control Act makes it possible for selected areas and premises to be declared firearm-free zones. For example, a school may be announced as a firearm-free zone, meaning no person is allowed to carry or store any guns or ammunition. If the police have grounds to believe guns or ammunition are in any of these zones, they have special powers of search and seizure for any premises or people present without having to first obtain a warrant.
So can you declare your property or premises a firearm-free zone?
You can apply to the South African Police Service to have your premises declared as a firearm-free zone. But only the Minister of Safety and Security can declare a firearm-free zone.
What will happen to you if you carry a firearm in a firearm-free zone?
Well, you will be arrested and prosecuted according to the offence you have committed.
Can an off-duty policeman or another government official carry a firearm in one of these zones?
No, an official is only allowed to carry a firearm in one of these zones while on duty.
Now, where do you leave or store your firearm when entering a firearm-free zone?
Although this has not been finalized, some firearm-free zones will have the necessary storage facilities available. As it is, there are a few options for licensed firearm owners. Where no storage facilities are available, your firearm can be stored at home in a safe.
General provisions concern the regulation of the registrar's powers and the various duties they may assign to people. the provisions don't really concern you as a private firearm owner or a license applicant. However, there is a point contained in this chapter that you should take note of.
If you inherit a firearm, you still have to apply for a competency certificate and a firearm license. While you're doing this, the registrar may issue you with a temporary authorization. And of course, you have to store the firearm in the prescribed manner. If you don't want to keep the firearm, then make arrangements with the registrar or your nearest police station to sell it to an appropriate buyer. We'll give you the police service's contact details and the person you need to talk to at the end of this video. Throughout the whole video, we've been referring to the registrar and the Central Firearms Register. The registrar is the head of the Central Firearms Register of the South African Police Service. The Central Firearms Register is the division of the police service that deals exclusively with firearms and ammunition and any matter relating to arms or ammunition. They monitor and control all licenses issued, they keep records of all firearms, all changes of ownership and any cases involving lost or stolen firearms.